guess my dumbass did not update my stream key settings. I've been waiting for to watch this shit all day, Darrell Brooks trial, and but I wanted to watch it and maybe watch it with some friends, see what happens. No, that's not right. I don't like that either. Hang on. Got a lot of shit going on here. Oh no, that's not what I wanted to do. Oh, okay. Alright, let's see. Alright, maybe that'll work. Let's see. Yeah, I guess so. Alright. So we're watching this stupid Darrell Brooks trial. Man, this guy's a freaking numbskull. He's having to be explained everything.
That process in any event, because it's being done in a secure location, is I have ordered that I want to make a record of what's being done, and I want a visual record of what is being done. And so this jury view is going to take place in the Sally Port of the jail, and precautions are being taken so that the jurors do not know where it's at. It'll look like a garage, right, or artificial. And I want to make sure that there's a record of what is done for this.
Then I have a right to not be present. How can this take place if I don't agree or consent to being present? How can it even still take place without
to stop the viewing?
Without me?
It will take place, sir. I'm just going to honor your request not to be there.
I'm asking a question though. How can it take place without my consent or agreement?
That's how
if you don't
you're not a lawyer.
It's going to take place. That's how I'm going to answer that, sir. So you not going there is not going to prevent it from happening.
Nope.
My law is
But you can forfeit your right or to be there by your conduct. And by your conduct, by not answering my question, by saying I don't want to be there and I don't consent to it, you will be forfeiting your right to be present and essentially waiving that.
Doesn't I have to sign something for it to be waived?
I don't think so in this case.
Well, yesterday you said something about
I know I said that, and I've had some time to think about that further. And I don't believe I need to take a full waiver with you signing anything or even agreeing to the waiver.
So why did I have to do that for when my
I'm not going to answer those questions because that would be for me to give you an explanation of the law.
No.
I'm just going to tell you that I'm not going to require a written waiver from you in order to honor your request to not be at or even if I phrase it, your lack of consent to the jury view.
And is that lawful law? Because
for your lack of
Sir, I'm not going to go through all the law that applies to that. This is my ruling. If you disagree with it and ultimately there is a conviction, you can raise that on appeal. But your lack of consent is not going to stop the jury view. It's going to happen. It's a piece of evidence that I cannot physically fit in this courtroom. It's too big. There's no way to get it in.
Okay, I'm informed of that, but at the same time, if I haven't signed any waiver, how could it be lawful? I haven't given consent or agreement to a jury view. I haven't waived any right. When the whole issue was brought up on the record yesterday, my first thing that I said was, I don't see the relevancy of why there should even be a jury view. And that was the whole issue. And yesterday I was told about I don't know how you say it, the colloquy or however you say it. I don't know how to pronounce it.
I know what I said. And I'm telling you, I had time to reflect. That was my initial reaction to your statement yesterday, but I've thought about it some more and I'm changing my mind. I don't believe I need to take a full waiver with a colloquy with you and anything in writing. I'm advising you, you have the absolute right to be there. But I'm also advising you that if you choose not to be there, I will honor that request And I'm not going to force you. I'm not going to direct the sheriff's department to, use any type of force, if you will, or require you or get you there without your consent. You either cooperate with that process or you don't.
The way I interpret the law, though, Your Honor, which the law is designed for.
The way you interpret the law is
to be interpreted by the people. The way I interpret that is I have the right, or essentially to be there or not to be there, and it still has to be an agreement or consent. That's how I interpret the law.
My ruling on that, sir, is I disagree with you. You do not need to provide consent for the jury view to happen. Your objection is noted for the record. I'll make a specific finding today that it is relevant to these proceedings, to this trial. There is an allegation that you drove through the Waukesha Christmas Parade on November 21 of 2021, driving a red Ford Escape, killing 6 and injuring dozens more. The relevance is that there is, in addition to the charges, there's an enhancer that has been charged as it relates to the intentional homicide charges and the first degree recklessly endangering safety, that you committed those acts while using a dangerous weapon. I would direct your attention to the meaning of a dangerous weapon, that the legal definition that was provided to the jurors in the preliminary jury instructions, and that the jury view is related to the evidence that the state is presenting regarding the charges, and specifically the instrumentality that they allege is the dangerous weapon. So there's clear relevance of this vehicle and has evidentiary value. Again, your objection is noted for the record.
It's pretty obvious. The guy did heinous things out of his own stupid frustration. And now he's just expressing stupid frustration in the courtroom, and I get why she's not holding him in contempt, because that just slows the whole process down further. So we need to get through this. But man, it's taken 2-3 times as long to get through a process, because he literally objects to every question almost. Which means that she has to overrule or sustain the very, very few that he actually gets, where she has to actually give him the... But he's just throwing everything at the wall, and it's just so pathetic. God, you're an idiot, dude. You're an idiot. You are the biggest fucking idiot ever. And honestly, you're making a mockery of our court system. Go the fuck home. You're drunk, son.
Sir, and what I'm putting on the record is that it does disrupt what I'm doing, and disruptive. I give you an opportunity to raise your objections and to make your legal arguments, and then I make a ruling, and then you start in on something else. You need to give me your argument all at once. For you to interrupt me afterward is disruptive to me.
It's not disruptive.
And it's interrupting, and it's disruptive.
Argumentative.
It is definitely not disruptive.
Well, if that's my view of things, sir, and what I'm putting on the record is that it does disrupt what I'm doing and the flow of what I'm doing, and needing to move on, having to interrupt what I'm doing so that I can address that once again. Please,
it's not the
please.
Darrell game.
I know you may not always agree with my rulings, but I'd ask that you show the courtesy and decorum that is expected of everyone, and once I make a ruling, we're going to move on. You don't need to keep objecting, because your objection's already been noted for the record. I'm going to continue. We're going to look at jury instruction 152. I gave the parties 2 documents yesterday. One was the pattern instruction, which I've modified, and then one is the draft of, and Mr. Brooks, please stop. You're continuing to talk over me.
Because you're interrupting. You said I have the right to object, and you didn't let me even get to the objection.
I did, sir.
No, you didn't. I was right in the middle of it.
Your objection comes before the ruling, not after. Once I make a ruling, we're moving on.
You made a ruling before we even finished the conversation, Your Honor. With all due respect,
Brooks,
before we even finished.
That's not true. Okay?
You said I'm going to make a ruling. as soon as you even started in about
That's so fucking stupid.
Mr. Brooks, I'm not
having
going
the
to
time to
spend
think.
hours on end making a ruling about a jury view on something I've already decided. All right, so please, I'm asking you to stop. Stop
Nah,
interrupting me.
You can't,
And please
you can't
listen.
just disregard the United States Constitution, which has a
I
supremacy
absolutely am
clause.
not disregarding the
You are.
United States
You're
Constitution
not
or the
honoring your oath
Constitution of
office.
the state
Your
of
Honor,
Wisconsin.
are you not a public servant?
Okay, Mr. Brooks, you're starting to cross the line. You've already crossed it, but I want to keep going. I want
didn't
you in
cross
this
any
courtroom.
line.
But if you keep interrupting me and putting you on notice that you run the risk of being forfeiting your right to be present in this courtroom and continuing in the next courtroom so that I can effectively and without interruption continue with the proceedings this morning.
So again, you're holding me in contempt.
All right. Jury instruction 152, has the state had an opportunity to review it?
Is that a judicial determination that I'm being held in contempt?
And I agree generally with the court's proposed instruction. I did submit kind of a counter-proposed instruction following much of the language that you had in your version, Your Honor. I just think it's maybe better to refer to this area as a garage instead of a sally port. I don't know that anybody knows what a sally port is unless they work in this industry. And instead of referring it as being in the Waukesha County Jail, I just suggested a garage attached.
The lawyer in the middle, she's been coughing like the entire time. I think she might have COVID. She might have been infecting me. And jeez, oh my God, these people.
To the admittedly just did that a few minutes ago. So that's why I emailed it to the clerk, because it's probably not in your queue yet.
No, where will I be?
No, never mind.
Going to will be read while we are still in the courtroom prior to the parties in the court going to.
Let's see what this dumbass had to say.
As it has been since the. I think everyone's.
To the word custody is it's factually true, but it's really irrelevant. And just to be cautious, Your Honor.
With that, sir, do you have any?
I don't fundamentally understand that.
Yeah, I know you don't understand that. You don't understand.
I think everyone's well aware that I'm in custody. So how does the wording change what's already known? Everybody knows that I'm housed in the Waukesha County Jail. How does the wording change what's already known? It's reported on every single day, as it has been since the beginning of trial and even before that. So I don't think anyone's not privy to the knowledge of where I'm housed and that I'm in custody.
You think you're. Congratulations.
How does
idiot
changing the wording
award
change
of
what's
the
already
fucking
known?
year.
Thank you. From my perspective, of course, when I drafted this yesterday, factually, what I put in there would be accurate because that's where the jury view is going to take place. I think changing the verbiage so that it says a garage attached to the Waukesha County Courthouse takes away any possibility that other law enforcement is condoning what is happening or somehow related to the case due to your concerns, etc. The jury view the accurate of this and to what they see during courtroom in the court.
So if I was there, where will I be at?
My understanding, if you choose to be there, is you will be escorted like you are in court here now. The bailiffs would be with you. You'd be in your suit.
No, where will I be at?
You would. I don't know exactly. That's up to the sheriff's department as to where all the parties are going to stand. Obviously, you would. We're not going to commingle you with the state or the state with jurors or you with the jurors or the court or anything like that. My understanding is we'll have sort of assigned places and that it's only myself who will walk around. And I may not even do that. I have to think about that. But the jurors are the ones who are going to walk around the vehicle one time.
So I don't get to walk around the vehicle?
I can have you do that before the jurors come in. I certainly can have you do that if you would like. I can give the parties that opportunity.
And may I add something else, Your Honor? I agree with everything the court said. I also think Mr. Brooks should understand that it will be a fair process. He's not going to be led into the room in shackles in front of the jury. What it's my understanding from Captain Dussault, the attorneys for the state, the prosecution team will be in the room. Mr. Brooks will be in the room. We will be in our assigned location. It will be fair. It will match. There will be basically no distinction between how Mr. Brooks appears to the jury versus how we appear to the jury.
The actual defendant.
We will be in there first. If the court's willing to allow him to walk around the car one time to look at it, we have no objection to that. And then the jurors will come in. No one will speak. They will do one lap around the car. They will leave the room. And then the parties will leave the room. That's my understanding, Your Honor.
And I will add to that, because it's been a while since I had some preliminary discussions with the Sheriff's Department on this, that if however many bailiffs, sheriff's deputies are with you, I want the same number with the state, right? And that's what we mean by it will look no different. So
I can't just walk around freely. With bailiffs, I'm sure there would be some...
all right.
Many of the same details that's being discussed right now at this moment.
All right, Mr. Brooks, do you have a request as it relates to any of that?
Well, yeah, I'm still trying to understand the whole how
because you
how this is all working, and then it was a reference to how the shackles would look, or how being shackled or not being shackled. I'm guessing that I can't just walk around freely. With bailiffs, I'm sure there would be some type of shackles.
I will tell them you are not to be shackled visibly for the jury to see.
And what do you mean by visibly, Your Honor?
So, obviously when you sit in court, you're shackled to a table. They can't see that. I'm not going to have you in belly chains or in leg shackles. You're just going to be escorted. And it will be up to them how they determine...
Well, he may be in leg shackles, Your Honor, if there's a table or some way that they can keep that out of the view of the jury. Just like he is in court. He's shackled in court. He has been for 3 weeks.
Actually, these are...
The security has to be left at the discretion of the Sheriff's Department.
Actually, these are leg shock devices, not shackles.
Sir, the security is up to the Sheriff's Department. I should be careful not to overstep my bounds on that. And, whatever is done, it should not be viewable or visible to the jury.
Shackle his ass.
And why is that, Your Honor? I don't understand that part. Why is the jury not privileged to see?
That is to your benefit.
Shackle.
I'm not going to explain that any further.
I don't understand. I'm just seeking to understand. I don't know.
All right, I need to move on. So unless there's a specific request other than a statement that you're making about your lack of understanding, I need to move on with the other topics.
There is a specific request. Why do I have to have ankle shocks on my ankles to appear at this jury view thing?
I guess I'm not aware of what you're talking about. So were you advised by the Sheriff's Department that that would be the case?
Well, the DA just said that I would have the ankle shocks on.
No, shackles, she said.
No, these are not shackles. They're a shock device.
Judge, I think perhaps we can move on. I think maybe because this is going to have to occur on a break, the bailiffs can take him down there if Captain Dussault is willing, show him what it's going to be like, show him how he's going to get there, and he can decide at that point if he wants to be there or not when the jury comes in the room. We're spending a lot of time talking about security and things that are frankly beyond your knowledge and my knowledge.
I object to that. I'm simply trying to understand, why do I need ankle shocks?
I'm going to leave the security. I'm not going to make any specific orders. I'm going to backtrack a little bit. I will leave the security of the jury view to the Waukesha County Sheriff's Department. That is their responsibility. And I trust that they will do what needs to be done to maintain the security, no different than what they do here. And in their discretion will determine how best that takes place. And if I need to address anything after that or at that point in time, then it should be brought to my attention, but we are going to move on this morning.
So I should discuss that with the sheriff?
Yes. So I know, Mr. Brooks, you filed with the court 2 documents. I'm going to take them under advisement.
No, it's
I'm not
one
going
document. It's one. It was 2 papers, but it's one document.
Oh, all right. Thank you for that clarification. It's 1 filing, 2 papers, just front side, entitled Alleged Defendant Jurisdictional Challenge and Mandatory Judicial Notice by Affidavit. It references the case caption, the case number. I will simply take it under advisement, and I'll review it later. And if I believe it needs to further be addressed, I will do that. But it's my understanding, sir, that you are requesting the original back. Is that true?
Yes.
So normally, just so you know, when documents are filed with the court, we maintain the original until it's scanned in and it's audited, and then because it under the statute, once it's e-filed or into the electronic filing system and the electronic case, I believe we just destroy the documents at that point. So I don't have an issue giving you back the original, but it needs to run the normal course. My clerk needs to scan it in. I've advised you of this previously, but in the courtroom, we don't have the time stamp. We just have the date stamp. I will state for the record that you provided this. It was right away at the beginning of the morning, so at 8:30 a.m. is when it was filed with the court, so that will be on the record. And then at some point today, as to what was filed this morning, as a courtesy, we will provide you back with the original once it's scanned and it's in my electronic file.
I was told that you make the decision if I can get the original copy.
And I just made a determination you could have the original back of this.
Can I have the originals for all my filing?
I'm not going to address that right now, sir. I don't have time, frankly, to look through everything that you filed to determine whether we've given you originals or not. In the future,
I have the copies. I don't have the originals.
All right, I'm going to move on,
I have
sir.
them here.
This is taking up valuable time with the jury. We need to keep going.
You dumbass.
Is that a judicial determination, Your Honor, that I can't get an answer to
I don't
something?
believe there's any other preliminary issues we need to address unless the parties have anything from the state.
Just very briefly, Your Honor, to advise the court, I have 4 witnesses here that I believe are very brief records custodian type witnesses on some video evidence. I'm hoping my direct should take 5 to 10 minutes for each of them. And then I have 2 police officers who will be testifying. There will be some physical evidence involved when those officers testify. And Detective Casey went to retrieve it and he will bring it to the courtroom. When that moment comes, do you want me to have Detective Reglan take the exhibits to the...
I don't know. They're not part of the record.
Wondering,
And other than the topics we've discussed this morning.
yeah, I'm still wondering when I will get the copies back for the ICFs that I filed.
I can't answer that. I don't have those, sir. You'll have to reach out to Clerk of Court Monica Paz.
Well, what happened to them?
I don't know. They're not part of the record. So you'll
They
have to
should
take
be.
that up with her by an inmate communication form and ask her for those. But I'm not going to address that any further on the record. All right, let's
should
bring the
be.
jury up.
It's kind of funny that they disappeared. No
That
ICF
assumes a
disappeared
fact,
before.
Not an evidence, sir. So
They haven't disappeared before. I've always got copies. What's the difference now?
All rise for the jury.
So I have to readdress her the same thing in order to get copies that I've always been getting since the beginning of you telling me to file ICF.
He does this
So as a
every
courtesy,
time.
if you want to make a
Jury's
list of
coming in.
whatever documents you believe you have not been provided copies with, I will, as a courtesy, instruct my clerk, Teresa. They're not going to be date or time stamped other than what's in the file. They'll be from the electronic file, but you need to provide her with a list, and then I will do that as a courtesy to you. But I'm not required to do that. But as a courtesy, I will do that. And as far as any ICFs, if they weren't directed to me, then you will have to follow up with Clerk of Court Monica Paz. I don't have them. They're not part of the file.
Then why were you getting them before?
You'll have to ask her that.
I have to ask her why you were getting them before?
My understanding is they were forwarded to me, sir, but
So what happened to this one being forwarded to you?
Sir, I can't answer that. I can't answer what I don't know. So
It
the
seems
jury's
like you're
coming
trying
in.
to
We're
avoid
going
it.
to keep.
That's
We're
what
going
it
to
seems
continue
like.
with the trial. So thank
Just
you.
like you've avoided subject matter jurisdiction. You haven't proven that on the record.
Oh.
Thank you. Go ahead, your witness.
Thank you. Good morning, Mr. Sherman.
Morning.
Sir, what is your job title?
I'm the IT director at Waukesha School District.
And are you aware as to whether or not the school district maintains security cameras at the buildings on the school district property?
Yes, we do.
Overruled. It's foundational. The witness may answer.
I'm sorry.
Yes, we do.
Okay. And specific.
It's hard to watch examinations because he literally objects to everything for reasons that he doesn't understand.
Specifically, is there school district property located at the address of 222 Maple Street or Avenue in the city of Waukesha?
Yes.
What?
Overruled. It's foundational.
He just objected to the fucking
witness may
address
answer.
of the
He
goddamn
did, and your
place.
answer will stand. If there is an objection, sir, wait until I
Okay.
rule on it before you answer it. Thank you. Go ahead.
He is dragging
What
this
building
out
is that location,
so
sir?
long.
That is our district
I didn't
office.
know that's for relevance. Or
And
ask
is there
for,
more than one security
grounds.
camera on that building?
No, objection.
Overruled. The witness may answer.
Yes.
Every
How many
fucking
are there, sir?
Overruled. The witness may answer.
I'm not exactly sure, but I believe there is about 8.
Okay. Directing your attention to the days following November 21 of 2021, were you contacted by the Waukesha Police Department for any reason?
Yes, I was.
For what reason?
They asked me to look at my external security camera footage to see if I saw anything unusual on it.
And that would be specific to the building at 222 Maple Avenue?
That's correct.
Oh, he,
Overruled. The answer may stand.
I'm going to show you an item that's been marked as, well, let me ask you one other foundational
hard to
question.
watch, man.
Do your security cameras record the activity?
Yes, they are recorded on a digital video recording system.
And can be viewed later?
That's correct.
Okay. So when the police came to you in the days following November 21 of 21, did they ask you to check a certain day and time on the video recording for the building at 222 Maple?
Objection.
Overruled. The witness may answer.
Yes, they asked me to look at Sunday. This was Monday. When they contacted me, and they asked me to look at Sunday at approximately 4:30 p.m. in that range.
The
Okay.
reality is that
Again, Your Honor, this,
we know this motherfucker ran down them people in Waukesha.
entire video is 11 minutes in duration. Based on the testimony of the witness, I do not intend to play any of it at this time, but I would move to admit 158.
Objection. It's not intended to play. What's the relevancy?
The objection is noted. It's overruled, and Exhibit 158 is received.
Thank you. I don't have any other questions, sir.
All right, thank you. Go ahead, sir. Do you have any questions for this witness?
Brief. Before today, sir, well, first of all, good morning.
Good morning.
Before today, had you seen these exhibits or videos, rather, 157 and 158?
I've seen this video when I collected it off our system.
And do you recall seeing the first one?
Yes, I do.
Do you recall when you saw those videos?
I saw those Monday morning when my detectives came and asked me to review video footage.
And do you recall the name of the detective that you reviewed the footage with?
I do not recall the name of the detective, no.
This usually ends in him asking stupid questions about Sovereign.
The plaintiff would be who's bringing the claim.
Oh, the plaintiff. Yeah.
Your Honor, I
Yeah.
object.
And it
Well,
just
I
ends
I
in-
realize there's no question at this point, but, Your Honor,
Or having a phone conversation with the plaintiff.
Yep. It always ends with a who's the plaintiff, who's the plaintiff, who's the
Do you
plaintiff?
recall if you were contacted by the plaintiff in this matter?
Do us to state.
He literally asks every witness these same questions, and they get objected to every time. It's like, I don't want to give him a plea for insanity, but the reality is that Einstein, maybe it was Einstein, but somebody said that the definition of insanity is doing the same thing over and over and expecting a different result. My only speculation from that is if he has anything up there at all. What he's trying to do is delay as much as he can, but he doesn't know how to do it because he doesn't know how court proceedings work. Which is somehow working in his favor? I don't know. It's fucked up. Let's see the defense team make fun of him for a minute.
Thank you, sir. You may step down. Direct.
Took it.
No further questions?
Any redirect?
no, Your Honor, I'd ask Mr. Schloman be excused.
All right, thank you, sir. You may step down. And he is excused. All right, good morning, Mr. Stone. If you would please when you get there, please remain standing. Raise your right hand.
This will be the truth.
Record and spell.
S-T-O-N-E.
Thank you. Go ahead, your witness.
Good morning, Mr. Stone.
Good morning.
Sir, on the date of November 21, 2021, where did you live?
I reside at 424 Dunbar Avenue in Waukesha.
Do you have any security cameras at your home, sir?
I do.
And do the security cameras have a way to record or save events that are captured on the camera?
They do.
Objection leading.
Overruled foundational. The witness may answer. And
He's
just so
trying
you
to
know,
object.
sir, if there is an objection, wait to answer the question.
40 seconds long, so I'm going to play it for the witness only. No,
Okay, thank
no
you.
further questions at this time, Your Honor.
All right, very well, sir. If you
The footage before today,
Same question.
for the reasons stated
Yes.
by the state.
also as to the form of the question.
Do you solemnly swear that the testimony you're
21.
Objection, speculation.
Overruled. The witness may answer.
Yes.
Does your security camera have record November 21 of 21?
Objection, speculation.
And
The witness may answer. It's foundational.
Yes.
security cameras at your home, sir?
Yes, I do.
And did you back then in November of 21?
Objection leading.
Overruled. The witness may answer. It's foundational.
Yes.
To your knowledge, were they in working order on November 21 of 21?
Objection, speculation.
Overruled. The witness may answer.
Yes.
Does your security camera have recording capability?
Objection leading.
Overruled. The witness may answer.
Yes.
And can the recordings be viewed at a later time?
Yes.
At some point close to November 21 of 2021, maybe a day or two later, were you contacted by the Waukesha Police Department?
Objection leading.
Overruled.
I was contacted
on Monday and on Wednesday.
Okay. Why were the officers at your house, sir?
My cameras are evident from the street, so they were curious if they were in working order and if they could look at them.
Do you believe that exhibit, what we just showed you, that video, is a true and accurate representation of the events that evening near your home?
Yes.
And if you look on the screen, sir, do you see a date and time stamp for the video?
Yes.
Objection, leading.
I had zoom. Okay, the feature of the camera zooms, so your image was real clear.
So the image was real clear when you had zoom. Any reason why this particular image doesn't have that feature?
They can do whatever they want.
Grounds.
Objection.
Hold on, there's an objection.
Sorry.
Let me rule on it.
Beyond the scope of the witness's knowledge, Your Honor.
I'll overrule if you know the answer.
I don't know what decisions they made in choosing the display.
It's got very spindly things.
And was that all you saw in the video, or did you see anything else unusual, or something that may have caught your eye, or?
Also, he wears a suit terrible.
That's the only thing that I was focused on.
Call with what agency you was contacted by?
That came to my
He's been
home
asking that question a lot.
on Monday,
When were
identified
you
themselves,
subpoenaed?
and then told me
And
that
how long did it take you to give
I'll
your
be detected
testimony?
Wednesday.
Blah, 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 blah.
Did you yourself follow up with law enforcement after those two
Yep,
visits?
that's the question he's asked every fucking witness. Just dragging shit out.
Subpoenaed to testify in this matter?
So when were you subpoenaed?
Any information about the subpoena?
Any information about the subpoena? Then he starts going in.
on a few days, getting
So the,
close to October 3rd, I made a phone call,
Plaintiff.
mental health interest.
Let's see.
How's everybody doing now? Are they okay?
Objection irrelevant.
Oh, he
sustained.
got called out for not asking
For relevance?
how
Yes.
people were doing in his interview with the police and the FBI. Now he's asking, how are people doing?
No interactions with the plaintiff in this matter?
Plaintiff, what I called it. No.
Stays to the form of the question.
You
Do you know if there's a
dumbass.
plaintiff in this matter?
Objection
Grounds.
irrelevant.
What?
Sustained.
Rejected over and over, over and over.
Grounds for
Every
sustained, Your
fucking
Honor.
witness. He asked for grounds
Not
for
relevant.
grounds for the ruling, which I don't think you get to do. Gets ruled on. It gets ruled on.
Do you
Yeah,
recall
Brooks
if the
did.
plaintiff in this matter reached out to you in any way?
Objection
Grounds.
irrelevant, asked and answered.
Grounds.
Sustained for those reasons. Also as to the form of the question.
Round.
Just for the record, it wasn't asked and answered. Just for the record.
Yeah, it's been asked and answered.
Next
Sonny
question,
boy.
please.
Do you yourself know if there even is a plaintiff in this matter?
Objection argumentative.
Sustained as to the form of the question.
This is what makes this hard to watch. He does this every time.
At some point, shortly after November 21 of 2021, were you contacted by the Waukesha Police Department?
It was actually that evening.
Okay. Tell us about it, please.
Well, actually, after everything transpired, I just got done setting up my Christmas light.
View the Christmas lights. You noticed a SWAT team in your yard?
Correct.
What do you mean by SWAT team?
Fully armed, rifles in hand, helmets on, officers in my front yard. Well, and on the street of my front yard. I should clarify that, in the street of my front yard.
Did you notice any vehicle that they may have been in at that time?
I'm sorry, could you repeat that question, please?
Did you notice at the time that you observed the SWAT, you identified the state of Wisconsin as the plaintiff? Have they ever reached out to you in any way?
Every fucking
Grounds.
witness.
There's no plaintiff.
Nope.
Not made my ruling. Thank you.
Oh, I love it when
Clearly
you start
stated.
saying
Mr. Brooks,
plaintiff.
please move on. I've made my ruling. Thank you.
Direct the defendant to move on.
Grounds.
The
I
objection
think
is
the judge has
sustained
to do that, not
pursuant.
the DA.
The objection is sustained. Next question, please.
I'm sorry, I didn't hear the reason for the sustain.
It's not relevant.
it's not relevant.
Your Honor, I object to it not being relevant. He clearly stated
Mr.
the
Brooks,
plaintiff.
please move on. I've made my ruling.
That's not
Thank
how
you.
that works.
I don't know how that's not relevant. Seems to me that there's no plaintiff.
I remind the jury to disregard comments made by the parties. They are not evidence.
There's no plaintiff. No further questions.
How about that? How about the
Thank you,
6
sir.
people you
I didn't read it
killed?
right.
No, I'd ask that Mr. Miller be excused, please.
That sounds pretty.
Sir, thank you.
plain
You may
shit.
step down and you are excused.
Thank you.
And they're being represented by the state. You jackass.
To be a plaintiff.
Dumb fuck. Ah. This is what we come to.
Take a short mid-morning break for about 15 minutes. I'll rise for the jury, please.
in the city of Waukesha. So we directed our team around that area, and we were going to start on the 300 block of Maple, and we were going to work westbound in the backyards until we got the address of 322 Maple Avenue, and the opposite side of the fence, which would be to the south of that, would be 434 Dunbar.
Okay. On to 98, please.
Shoulder height, and he turned a bit from right to left in front of the jury.
So you yourself didn't know until you were told. Would that be fair to say?
I was part of the brief, so I knew too.
He said, "Oh, well."
So you knew
the name
before
of the
you were
suspect
briefed?
at the time. No,
Yes.
I learned it by watching the fucking all the reports.
So you knew before you were briefed. Then why did you have to be briefed about that information?
Just the gatherings, we briefed
You
every
don't
morning,
understand
and the
how
gatherings
these things
from
work, you dumbass.
just didn't.
So it'd be fair to say you didn't know who the items belonged to at that point.
Yeah,
Fair enough. Yeah.
yeah, because we investigate things. You jackass. I like how he stands up, like tries to look all lawyer like he knows what the fuck he's talking about when he has zero clue of how the law works. He just stands there flipping through his pages.
In reference to the items, like what may be done to the items.
Yeah, they would place them into inventory at the Waukesha Police Department. So that's Specialist Schmidt's primary job role at the Waukesha Police Department.
So once you turn over the items, that's pretty much the end of your part of it.
Yes.
I don't have the information. Does his Bible say when? I can't tell what it says. Whatever that. piece of paper? What is that?
Would it be fair to say that these items have been kept for quite a while now? Would that be fair to say?
Yes.
Are items usually kept for this length of time? In
Well, you know
investigations?
what? If you keep dragging shit out, then
Yes,
just might
typically, yes.
fucking be. Fucking idiot.
And as to the form of the question.
Alleged defendant.
Objection, irrelevant.
Sustained, not relevant. Redirect.
No. Objection, irrelevant.
To the best of your knowledge, who can bring a claim against an alleged defendant?
Objection, irrelevant.
Sustained, not relevant.
Fucking.
Sir, Your Honor.
All right, thank you. Sir, you may step down.
They're just ready to be done with their part. They want to rest.
I could start with another officer, but I don't think I'll complete his testimony.
What I'd like to do at this point is advise the jury about what is to happen next. I'm advised that everything is ready to go. So, ladies and gentlemen of the jury, you will now be taken to a garage attached to the Waukesha County Courthouse to view the garage with the evidence to when to bring them over.
Let's see if you're gonna run your mouth some more before you go.
The question was asked about whether they could bring notebooks, and I instructed that they should not.
But wait, there's more.
And then I instructed the jurors at that point, our civilian bailiff, Michael, was in the lead. I said, please come in, walk around the vehicle one time slowly with the jurors, and then exit. That is what they did. 2 videos were made. One was prior to anyone being in there. It was just the sheriff's department personnel, I should say prior to the parties being in there. And they took a video of the garage and then a walk around the vehicle that was provided to me at the conclusion. It was on a large type drive, and then I provided that to Mike Nyman and Zach Tremaine, who then provided that to the media. And then the second part where we all were in there and the jury came through, that was also captured on video. All of that was put on a flash drive and will be marked as Court's Exhibit 1, along with the doc.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
Finally. Fuck yes, it's a judicial determination. Yes.
All rise for the jury.
God, she's that soft on him. I hope she's soft on the other side, too. Could be a lot of shit. Blah, blah, blah. My understanding is this gets more spicy at some point. I don't know when.
All rise for the jury.
From homeowners on Dunbar.
Objection, pleading.
Overruled. The witness may answer.
Yes, we did.
Specifically 430.
There's been significant evidence to demonstrate that he.
We're back out so we can see the whole map at this point. We will zoom in a moment, but the northern.
Since the focus on the question, so you can hear them clearly.
Objection argumentative still assumes the fact, not evidence.
Sustained.
No.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance.
Grounds?
Oh. Overrule the witness may answer.
That doesn't make any sense.
I don't understand your
Dumbass.
question.
Like, quit watching court TV.
Were you
or
able
quit
to hear my
watching
question
fucking-
clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next.
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair
What
to
did he
say
say?
that.
Oh, he talks about raising complaints. That's his line of reasoning right now.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of?
I don't remember the time exactly.
Already answered that. Stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection relevance.
Grounds?
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay.
It's comments, dude.
That exhibit and take it.
Definitely wasn't compound.
What?
Do you know of anyone who filed a claim in relation to this incident?
The claim.
No.
Plaintiff.
Do you know who the plaintiff is in this incident?
Objection
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
Well, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or an entity?
Objection
Grounds.
argumentative.
Sustained on relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant,
Every
legally
time.
inaccurate.
Grounded by the plaintiff in this incident.
Sustained as
Wisconsin, a living, breathing human being?
relevant. Sustained. Not evident.
Knowledge.
Relevant.
Sustained topic.
Any interaction with the read or seen a complaint?
Redirect.
No, thank Miss, please.
All right. We can. Good afternoon. Right hand and. No. Yes. Thank you, sir. Proceed. For the record and the.
SCHULTZ. Enforcement since 2014.
What is your current position?
My current position is the mechanical inspector for the Wisconsin State Patrol Technical Reconstruction Unit.
Can you describe the duties of that position?
Objection, relevancy.
Overrule. The witness may answer.
My job basically is to conduct thorough and systematic inspections of vehicles that have been involved in crashes. That can entail something as simple as taking photographs and looking at light bulbs to something more in depth, or actually take the vehicles apart and actually look at the moving parts of the vehicles.
Did you receive any training in order to perform those duties?
Objection, relevancy.
Overruled. The witness may answer.
Yes.
Can you briefly describe that training for the jury?
Objection, relevancy.
Overruled. The witness may answer.
A lot of the training that I received was on the job from prior inspectors. Prior to this, I was a diesel mechanic, and in addition to that, I have ASE and SAE certifications.
And having any interest in cars, what are those certifications?
Objection, leading.
Overruled. Foundational. The witness may answer.
SAE is for the electrical components in a car, basically, for the part that I am certified in. ASE is for the mechanical components, which stands for the Automotive Service Excellence, is what I believe it stands for.
What is the purpose of a mechanical inspection?
The purpose of a mechanical inspection is to determine if there was anything that was incorrect, defective, or broken on a vehicle prior to the crash that would have caused the vehicle itself to cause or contribute to the crash.
On December 6, 2021, were you directed to go to the Wisconsin State Crime Lab to view a vehicle?
Objection leading.
Overruled. The witness may answer. It's foundational. Go ahead.
Yes.
What information did you have prior to going to that location?
Objection speculative.
Overruled. The witness may answer.
The information that I was given is that I was to set up an appointment there to look at a Ford Escape that had been involved in a crash in the parade in Waukesha.
Literally an objection.
Did you go to that location on that date?
Yes, I did.
Did you do a mechanical inspection of the vehicle that you were?
Understanding has previously been provided to you. You have.
In this case, it's an automatic transmission, doesn't have a clutch, you don't have to shift the gears, and it's front wheel drive, meaning that it's not all wheel drive or rear wheel drive like a pickup truck, it's just front wheel drive.
And is there a picture on the front of Exhibit 83?
Yes.
Objection leading.
Overruled. The witness may answer. Just a reminder to wait until I've ruled on any objection. Thank you.
Yes.
Because
And
he
what is that
objects
picture
to
of?
fucking everything.
It's a picture of the 2010 Escape.
That you did the mechanical inspection on?
Objection leading.
Overruled. The witness may answer.
Yes.
Not know how long.
Have you authored this report?
I did.
Have you had a chance to review it since you've authored it?
Yes.
Is the information contained within this report accurate?
Objection leading.
Overruled. The witness may answer.
Yes, it is.
I would move State's Exhibit 83 into evidence.
Objection.
Your objections noted. It is overruled. Exhibit 83 is received.
So is my paperwork ever gonna say Exhibit 83, or is it just gonna be this?
There we go.
Mr. Brooks, I'll take that up outside the presence of the jury later, but we're going to continue.
It
Go
was brought
ahead.
up in front of the jury.
Mr. Brooks, we're going to continue with the questioning of this witness.
What is y'all trying to pull here?
Mr. Brooks, please.
This is
No one's.
no, please, nothing.
The exhibit, to my understanding, has previously been provided to you. You have it. It's now been marked as an exhibit for trial
Y'all got
purposes.
something I don't have though.
I don't have that.
Go ahead.
That's not how it's supposed to work. It's supposed to be fair.
You
Basically,
know
I
how
trust
it's
that this was
supposed to work.
previously turned over.
It
With
was,
your
and I believe the defendant has a copy of it.
0%
Thank
experience.
you.
Where does it
Please
say
continue.
Exhibit 83? It doesn't say that this was going to
Again,
be
we'll take
used
this
as
up
an
outside the
exhibit.
presence of the jury later. It's not something we need to do right now. Go ahead and ask your questions.
Thank you, Your Honor. And I would object and move to strike from the record any commentary that the defendant was making in the last 5 minutes.
What was that?
Court will strike the commentary that was made. I'm not sure if it was picked up or not, but as a reminder to the jurors, the statements made by parties and lawyers are not evidence. The testimony and other evidence that's received is the evidence the jury will ultimately consider. Go ahead.
Thank you. Sir, can you briefly describe the condition of the vehicle when you inspected it on December 6th?
Yeah, the vehicle had quite a bit of front end damage. The bumper cover was pushed back, the grille was pushed back into the engine bay and into the radiator. That was also pushed backwards in towards the engine. The hood was folded up in the air. Both lights were broken out of the front. There was quite a bit of debris and unknown things stuck to the exterior of the vehicle. And there was also some damage to the sides of the vehicle.
Do you know why you had to go to the Wisconsin State Crime Lab in order to do the inspection?
Objection leading.
Overruled. The witness may answer.
I was requested to go to the state crime lab to do the inspection because they had not yet completed DNA sampling. So until they had it finished, it was going to be retained inside the crime lab. So in the interest of not moving the vehicle again, once they were done with DNA, they had me come to the crime lab to do the testing and inspection.
So the first section of your report, and I'm just going to direct your attention to page 3 of Exhibit 83, talks about the tires and the suspension and tie rods. Do you see that?
Objection leading.
Overruled. The witness may answer.
Yes.
And can you describe for the jury what part of the inspection, describe this part of the inspection?
Objection leading.
Overruled. The witness may answer. The report's been received by the court, and the state may direct the witness to various points at its discretion.
Every damn objection just draws everything out.
Go ahead, Attorney Basie. You may continue.
Thank you. Sir, can you describe the information contained in the first section of the report under the heading tires, wheels, steering, suspension, brakes?
Objection leading.
Overruled. The witness may answer.
So under this section, it's broken down into 4 parts. One for axle 1 left, which is the driver's side front axle. The left side would refer to it as you're sitting in the vehicle facing forward. The right side would refer to the passenger side. So axle 1
leading.
Sustained as to the form of the question. Please rephrase.
vehicle muffler without seeing the ends of it and where the inlet, outlet are, and actual measurements. It would be impossible to say what vehicle it came from. But
assume you meant the axle.
All right, thank you.
He does. He literally makes them repeat like every piece of evidence they produce. Just drawing shit out as long as
So
he
you
can.
testified on cross-examination that the right and high mount brake lamp were inoperable. Do you recall that?
yes,
How about the left brake lamp? Was that operable?
Let's guess if his last question is about a furnace.
no, I would not have a way to tell when.
You would know either way.
No, I would not have a way to tell when that light bulb went out.
Correct. Before you do that, I'm just. You can stand here.
Control braking.
No, it does not.
Did-
They were not.
Now, your inability to fully inspect the engine, I want to direct you to that area of the vehicle. Does the engine control acceleration?
Objection. Relevancy.
Overruled. The witness may answer.
No, it requires driver input.
Does the engine control braking?
No, it does not.
Does the engine control steering?
Objection. Was the relevancy.
Overruled. The witness may answer.
No, it does not.
Does the engine control gear shifting?
Objection. Relevancy.
Overruled. The witness may answer.
It does not.
Finally, sir, you had talked about
306 will take about 15 passes. I'll excuse the jury. And, I will take that. Thank you. Step down.
No.
Thank
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. The 2nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. Testimony at that point in your report, once the proper foundation was that specific exhibit sticker, know from your cross-examination, it's clear from your questioning that you had reviewed it. I would just note 2 examples. One exhibit
report, tie rod, clarity.
And so I just wanted to
that
make
didn't come from the report, Your Honor. The
a
only
record
thing
of
that
that.
came from the report was from page 9, when I was trying to get clarity about why it said worn tire tie rod.
Oh, and you actually questioned the
And-
witness about the different tire and what that would mean. So I thought 3 good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, any direct examination, sometimes that does mean there's some repetition, but in you, sir.
Do you understand what I was saying?
You are part of that. I am going to improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
You are, but you, during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir,
Because I
you
don't-
say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say
Mr.
it
Brooks,
wasn't
I'm
fair?
just making a record because
Yeah, but
it's
you're making
important
an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling
Mr.
disrespected?
Brooks, I'm not going to engage in this
'Cause I don't think he
back
did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah,
number
but your
two,
observations
it's my
are
job.
incorrect.
It's
If
my
it-
job to ensure that under 906.11, that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to
906.
read it. Just make sure that you make a correct
The judge shall exercise
record.
reasonable
Don't lie on the
control over the mode and order of interrogating witnesses and presenting evidence
it's gonna
so as
get
to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr. Brooks' objections. his
I don't
response
consent to being
was,
called that name,
stop
Your Honor."
trying to be slick.
Yeah, I did say that.
So,
All right.
just for the record, I thought that that was very disrespectful.
Thank you, I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When
return?
we come back.
Why
Okay,
wasn't that
thank you.
addressed right when it happened?
Honestly, Mr. Brooks, I'm really trying hard not
Because
to
that's
highlight
that's
your
the definition of trying to be
misconduct
slick.
during the trial. I'm trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead
I
pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I don't
But all right, we're in
refer
recess.
to what
Thank you.
conduct
It's
you referring
3:14.
to. If you're gonna be biased, then somebody.
Analysts to testify.
Record. Do you want to talk scheduling?
Yes, Your Honor, thank you.
Go ahead.
And thank you for a little extra time here. I spoke with the defendant about his witnesses for tomorrow, and I believe he's filling out the paper that I asked him to so we can get his witnesses here. I can tell the court this: I have 2 crime lab analysts to testify yet this afternoon. They're both here. One's the next one is from the Milwaukee lab. The second one's from the Madison lab. So if we could complete their testimony today, it would be greatly appreciated. I don't know how late you intend to go today or how long it will take, but I'm being optimistic.
Nights we did break at about 4:30, 6 o'clock if need be.
So how late do we plan on going?
I didn't see if there was any reservation or have the state make an offer of proof and we can go from there, but I'm not gonna do that right now.
Yes, I do.
If need be, if we can get through those 2 witnesses and Detective Casey, that would be great. But let's see how we go.
Okay, thank you.
All right, sir, did you have anything?
Yes, I do. Detective Casey already testified. What would be the significance of him testifying again?
Well, let's take that up later. I want to deal with the lab analysts who are here first and not delay their testimony any further. So, other than that issue, do you have anything else?
Yeah, I thought he was released from his subpoena. At least that was my guess.
I honestly don't recall whether that question was asked of me. I know he's the court officer and he's been here. I'd have to take a look at the record from when he testified and see if there was any reservation or have the state make an offer of proof and we can go from there, but I'm not gonna do that right now. I wanna have those lab analysts testify, they're here. And we can take up more fully the issue with Detective Casey after they're done testifying.
So how late do we plan on going?
I will go as late as 6 o'clock if need be. So I wanna keep pushing along,
Yeah, that's definitely pushing it here.
That's not that late, sir. We've stayed till 5:36. Previously, there were times during jury selection we stayed till probably 7 or 7:30.
In my
The last
position-
2 nights we did break at about 4:30, 4:45, and so I'm willing to go a little bit later tonight. So it's 3:30 now. We'll see how things go.
I was making that saying that on the record because in my position that is kind of late.
Well, let's start now and we'll get going, and maybe we don't have to go that late. So bring the jury out.
Are we going to address subject matter jurisdiction?
The written decision that I previously entered is what I will stand on. I'm not going to address it any further.
Is that verified proof?
Sir, my written decision is the decision on subject matter
Is it
jurisdiction.
verified proof?
Narcissist, motherfucker.
Because it hasn't been proven on the record and that was not verified proof.
What is that, please?
Judge leading.
The witness may answer.
If law enforcement is at the scene and would like the crime lab crime scene response team to respond, they simply call the lab that's in their jurisdiction, and basically the call will get routed to me and I'll dispatch a team to the scene.
And on November 21 of 2021, was the crime scene response unit asked to respond to an incident in the city of Waukesha County?
Office, their secured facility.
The true 12.
Noted. Exhibits 105, 106, 107, 108, 109, 110, 111, and 112 are all received. Permission to publish granted as to all.
The
Overruled. Foundational. The witness may answer.
The front bumper is secured in somewhat, should be its original position with those bungee cords that we previously talked about.
Okay.
Showing
Match the pieces of the bumper to the frame of the body, or is that just the way it came together?
Objection. Speculative.
Overruled. Go ahead, you may answer.
at this time, I was not trying to physically match anything together. It was just for the purpose of securing it for transport.
Okay.
Doing stuff without, should be a fair trial.
It was
I wouldn't be.
To ask a question about 117.
The address, your objections noted.
3209.
Thank you.
Objection, that should be strike. When he asked the question, he said he didn't recall. So how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objections noted. It's overruled. The answer will stand. Go ahead, next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it, please, Madam Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask your
I have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I wouldn't
noted
be able to do that.
Your objections noted. It's overruled. Go ahead, Attorney Opera.
So that needs to stop happening.
In
It needs
addition to
be
the
fair.
hat,
All right, I'm going to excuse the jury. All right,
for the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. You shouldn't be able to do things without my knowledge. And then pass it off to the jury like that's fair. They deserve to know that too.
The rest of you can have a seat as well. As soon as the jury's out, I'll make a record. That the reason
consent to being-
document. Right, Mr. Brooks, you are well aware that the reason
consent to being
documents
called that
are
name.
being put on the
I don't consent to
witness
being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how
attempting-
did it get there?
Sir, do not
I'm not
interrupt
enti-
me, or
I'm
you will
not- I'm not
forfeit your
entitled
right
to
to be
know how I got
present
there?
in this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
Who has to be held in contempt?
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again, or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're gonna clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
gonna start talking, and if he interrupts, then I will close this courtroom and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not gonna allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05, there was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35, at 3:06, there was the hilarious comment, at 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses. Okay?
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being able.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be quiet?
I'm advising you to be respectful when the jury comes out.
Are you telling me to be quiet, or are you asking me?
I'm asking you and advising you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower
all
your tone
adults
of
in here.
voice
I've
and
never
not yell at
told
me,
you to
sir.
do anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me.
Ask me.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody.
Oh, hell yeah, they are in prison, bitch.
I don't have a problem with doing what you asked me to do.
Oh, they're
not
gonna
tell
lay you
me.
down. They're gonna axe you. You're gonna have an axe.
Just
too.
like when
That's
I
they know
asked
what
you
you're doing.
about subject matter jurisdiction that you have yet to prove on the record.
Fucking bullshit.
But somehow I'm
sorry.
being intentionally disruptive.
Your
Come on, man.
jurisdiction
Stop.
is about
Just
to
stop
be
it.
Subject.
Jury's coming out.
All rise for the jury.
Not gonna work.
Oh, it's I mean, not in a good way for you.
I'm supposed to be scared of getting removed or something.
Oh, here we go. What did he say? I don't like the way that I don't like that I'm gonna lose. Even though I ran over how many fucking people did you run over? You sick fuck. Fuck you. I enjoy watching.
Thank you, everyone.
you
Please be
fucking
seated.
idiots So I can watch you fry.
Statement
I hope you
continue
get
its
to watch this.
examination of this witness. I believe we're on Exhibit 117.
Yes, we had 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front.
Maybe
Overruled.
passenger.
Yes.
What do you remember that item was?
A TV,
Okay? And to the left of the TV,
fired bullet fragment from the rear cargo area of the vehicle.
okay. Was there any evidence that that bullet traveled?
So as far as you were concerned, you was basically just taking in the evidence as a precautionary thing, or?
Yeah, it was an item that just seemed out of place, so I collected that hat.
Did you at any time obtain knowledge about the relevancy of that?
No.
All right, so I want to say what he's trying to do is he's trying to implicate these persons. He's like trying to attack all of these individual officers, the FBI, the cops. He's trying to pull them out and put some sort of blame on them, which is, I guess, somehow supposed to absolve him of his actions. I don't know. That's the most fucking retarded defense I've ever heard in my entire life. The jury is going to hang him, because he's fucking retarded. And I'm sorry for using the R word, but uneducated, severely uneducated, illogical, irrational, poor parenting. I mean, that was his mom's car, right? That he was driving. And I bet he had treated her. Gee, I wonder why she ain't there to support him. Where's your mom? Where is your mom? I want to put his ass on the stand, see what he has to say.
All the photographs that you were shown, had you seen those photographs before today?
Yes.
Do you recall if they were taken the same night of your investigation or multiple nights or days, rather?
There were multiple days.
And do you recall why you had to, or do you recall why those photos had to be taken over a multiple day span?
Alright, so he's got three things in mind. First one is he's trying to establish like a length of time for their evidence. Second is he's trying to establish that there was no complaints. And then third is that there's no plaintiff. Right now he's trying to establish there's too much time between when blah blah blah, and then so what he's gonna go into after this is gonna be it's gonna be about the affidavit, when you received the affidavit, when you showed up for the affidavit, and how many times you reported back to the DA's office for the affidavit, blah 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 blah. We've done the same thing for every fucking witness. This guy has no. He's just drawing it out as long as he can, reestablishing the same facts that have already been proven, typically.
Yes, the vehicle needed a comprehensive evaluation or processing examination.
And
yes.
When did you start actually? So pretty much roughly at the same time.
The examination itself does not include or
as not every detail, but pretty much like it's much as would be relevant, but not every single detail. Would that be fair to say?
This report is comprehensive in the terms of it lists every single item that was collected.
So why would you refer to it as a summary? Well, maybe that's where the confusion comes in.
The record would reflect this witness. His last name is Johnson, so I think that's understandable.
Yeah, I didn't know. I was just reading what I have here.
Fair enough. Keep going.
Pertaining to the vehicle in this incident.
Yes, I have obtained a copy of the search warrant.
Yes. Then
any biological fluids, hairs, fibers, any electronic equipment, any personally identifying information.
Well, he's stepping down if my jurors and anyone else in the
Person to just walk up and. Mr. Johnson. Irrelevant.
if you saw in this matter, grounds.
I fucking called it again.
Do you see the plaintiff present in court today?
Yep.
Consider yourself to be.
Just very briefly. Mr. Johnson, you said when you arrived on Maple Street there were police officers present?
That's correct.
And you said the vehicle was secure at that point?
Correct.
Objection.
What do you mean?
Leading.
The answer may stand. Next question. Overruled.
What do you mean by that, sir?
The perimeter was secured with crime scene tape, and there were officers that were standing at the location where the vehicle was.
Would it have been possible for a member of the public or any curious person to just walk up and touch the vehicle or do anything to the vehicle?
Objection. Speculative.
Based upon his training and experience, he may answer. Overruled.
They would have been stopped by law enforcement.
Thank you, that's all I have.
All right, thank you, sir. You may step down. Well, he's stepping down. If my jurors and anyone else in the courtroom want to stand, I do want to get through one more witness tonight.
And then the exhibits that Mr. Johnson has, Your Honor, what would you like done with those?
I'll take them.
All right.
I have 90 and 87.
Yes.
Apparently he's angry. He's not.
What was 87?
87 is
Objection to that. That.
No, my God, here we go.
okay. I'll put that back.
That is evidence.
a hat.
I'm not,
87 is a hat.
I'm not sure if I did move that, but I would move that into evidence, so we will need that item for the next witness, please.
Oh, okay, I'll put that back.
Thank you.
Objection to that.
Noted.
Before
it's-
you showed me that, I didn't even see what that was. If you would have never
showed
told,
you again.
I know, but if you never would have told me, I never would have even know what that was, because I didn't see it till you just moved it.
The witness had it up on the stand, but here it is. It's exhibit, marked as exhibit 87. Go ahead and sit. State has moved it into evidence. I believe there's an objection. It's
Yes,
noted,
there is an objection.
Overruled based upon the testimony of the prior witness. It is received. And who do we have coming up to the stand?
Your Honor, the state next calls Trevor Naylid, and for the record, he was handed a copy of Exhibit 91 on his way to the witness stand.
All right. Thank you, sir.
No, just the lab accreditation.
Just the lab, okay. How many forensic DNA cases have you worked?
Just over 500.
And about how many DNA samples have you processed?
And a lot of times we'll swab the back of the neck area or the cufflinks.
Do you recall when you did this DNA analyzation rather? I'm sorry.
On any specific item or all of them?
Do you recall when you did all the items, I guess?
So most of the items were collected in November. They were not transferred to the Madison lab until the end of January. So I started, I believe January 31st was the first day that I started analysis. And then
I kind of like how he treats all of his
was written
witnesses,
April 29th.
including the ones that he
So you
called
started the analysis
one
at
so
the
far.
end of January,
Correct.
He pretty much treats them all
and
as at
you
least
did your
semi.
report in April. Why so long?
I generated 583 pages and my report's 15 pages long, so that takes a little bit of time.
So you broke down the 583 pages into 15.
God, you gotta quit watching fucking Law and Order, man. I can't play this game with you.
Page are you on, please, sir?
6.
All right, so you want the directing the witness.
Single source, or yes, I guess it would be called single source.
No. From page 6 to 13, as you previously stated, those are my star mix ones, so each one of those is going to be a mixture profile.
Which you've stated you've done numerous times.
Yes. Sir, on page 6 of your
Get right to this when it gets good. They quickly address all the stupid things that he said.
No further questions?
Thank you. Any redirect?
Yes.
Oh, yeah.
Sir, on page 6 of your report, you were identifying for the defendant the some of the single source profiles that you developed. Do you recall that?
Yes.
And one of the items you described as items CC4A, CC5A, and CC8A. Do you see that?
Objection leading.
Overruled. The witness may answer. Go ahead.
Yes, I do.
What do those items represent?
Objection leading.
All right, I just want to point out, yesterday she told him, since they're redirecting, they have 100% ability to lead the fucking witness. Also on cross. What the fuck? You morons! Delaying the inevitable for as long as possible is not a worthwhile strategy.
Overruled. The witness may answer.
Those are cuttings of the apparent root ends of the hairs that I took off the sweatshirt.
Forgot to ask you about the hairs.
Objection leading.
Did you? I'm sorry, that was a statement. I'll move on, Your Honor.
Thank you.
you told Mr. Brooks on cross that you developed a single source profile for those hairs, is that right?
Objection, I don't consent to being called that name, and it's leading the witness.
The objections are noted, overruled, the witness may answer.
That's correct.
Who was the source of those hairs on that sweatshirt, states exhibit number 84?
Objection, speculative.
Overruled, go ahead and answer.
Darrell Brooks is the source.
Thank you. Nothing else.
Great, thank you, sir. You may step down. As much as I would love to have another witness, I'm trying to break for the night because it is instruction that I've been giving every night to the jurors. So please listen. Do not begin the law with the juror. Will see their part. Listen to any conversation helpful to you in either news report, application, or applications. Seek information you obtain is unfair. Communicate. Do not use applications for media post. With you of any based on this, and it is the trial is completed. You are free attended to another juror with these rules offered with the party. Just briefly as to scheduling tomorrow, since we had a late evening, how about we start at 9 a.m. tomorrow? Any objection from the state?
No.
From Mr. Brooks? No. All right, 9 a.m. tomorrow. For scheduling purposes, I'll take up, obviously, tomorrow morning, whether the state can recall Detective Casey. That would be your last witness.
Yes.
All right, then, sir, you have the option, should you choose, of
the state was gonna rest today, but they couldn't rest because Darrell Brooks is such a moron. For some reason, the court is coddling him. And what I foresee out of this is that more people are going to manipulate the court system, especially now that we have this, like, bailless, just, get out of jail free card. We'll see. Good luck.